Mr. Mapunda, can you call the
Judge, this is the leave to appeal involving following cases. Case number 4597 of 2021 and case number 46468 of 2021. Also, the case of 46701 of 2021. It's the appeal of Mr. Zuma and the National Commissioner of Correctional Services.
May counsel then place themselves on record?
As it pleases court, my lord, I appear with my learned friends, Mr. Masuku and Ms. Libakeng, for the applicant, previously third respondent, Mr. Zuma, in this application.
May it please your lordship, I'm Patlele MS. I appear for the National Commissioner together with my colleague, Advocate Ndebele.
Mr. Mpatlele?
May it please the court, I appear together with Mr. Bishop and Mr. Willifear as before for the DA in case number 45997 of 21. We are the respondent in both applications.
Thanks, Mr. Chairman.
May it please the court, my lord. Max DPC. I appear together with Ms. Tobela Mkalisi and Ms. Kreyer on behalf of the Helen Suzman Foundation as before.
Thanks, Mr. Duplessis.
May it please the court, my lord, FJ Labuskaghni, in matter number 46468, appearing for Act Forum.
Thanks, Mr. Labuskagh. Over to you, Mr. Mpofu.
Thank you, my lord. My lord, because of the lateness of the, or rather even the exigency and the short time that was given to the parties, I will not traverse some of the usual issues about the test. The Lordship knows the test, and I will go directly into the grounds of appeal, subject to stating that we had reserved the right to supplement the grounds of appeal, but because the application is being unusually heard even before the time within which to file the application for leave to appeal has expired, we have not, or we will not have that opportunity to supplement the grounds. Be that as it may, we would like to address your Lordship mainly on 7, possibly 6 topics, very briefly, on the basis of which it is our respectful submission that this is a case that cries out for reconsideration by a higher court, and in respect of which the prospects of success are, as was indicated in our application, overwhelming. In addition, your Lordship will notice that we have also relied on Section 17A1 Roman 2, which is the section that deals with other compelling grounds for the appeal to be heard. But with respect, we are of the view that your Lordship, merely on the Section 17A1 Roman 1 ground, ought to refer the matter. We will, at the end, address your Lordship as to the forum. There is, of course, the possibility of the matter being referred to the full court or the Supreme Court of Appeal on appeal, and we'll address your Lordship in closing on that aspect as well. My Lord, the Lordship knows that in these kinds of matters, one would normally start with the preliminary points. In this case, the preliminary points of mootness and standing in our respectful submission were incorrectly decided. And then one would then go to the merits of the review, the judicial review application, because this was not a Part A application. As in the judgment, there's an allusion to some proposed action. There's no other proposed action. This is it. This is the main application, unlike the normal Part A and Part B application. And then, of course, one would deal with remedy. But I wish to change that order, my Lord, for reasons which will become very clear. And I wish to start with the question of remedy. And that is because the remedy that has been proposed demonstrates probably the clearest example of why, in our respectful submission, Your Lordship should grant the application for leave to appeal. And the issue is this, my Lord. Your Lordship, at the application of at least one of the applicants, the Helen Suzman Foundation, has made a finding that the period served by Mr. Zuma, that he is currently serving under parole conditions, should not be counted in determining the length of the sentence that was imposed by the Constitutional Court. Now, not only is such an order completely out of kilter with with any precedent, but it is also out of kilter with the law on parole, or the meaning of parole in the very first place. And in fairness to the other applicants, not even AfriForum and not even the Democratic Alliance asked for such an order. Only the Helen Suzman Foundation did. And as I was saying to somebody, Helen Suzman must be turning in her grave that such an outrageous proposal was made in the first place. As someone who used to fight for prisoners' rights. And that takes us to the law. Let's just look at the most basic legal issues that arise here. One, we have quoted in the application for leave to appeal the Constitutional Court authority, most recently in the Sonke gender justice case, which makes it clear that prisoners in a constitutional democracy do not lose their basic rights. And they may retain all their basic rights, except, of course, the rights that have something to do with their incarceration. And in that case, the Constitutional Court specifically mentioned the right to medical care, and in the cluster of rights that is referred to by Justice Theron, I think. The Lordship will see that in our at page 7 of our application for leave to appeal, where Justice Theron said, Section 35(2) of the Constitution addresses the general rights of detained and incarcerated persons, including the right to living conditions consistent with human dignity. This entails, among other things, adequate medical treatment and the right to communicate with their spouses, next of kin, religious counselors, and medical practitioners. And then, of course, in the same judgment, the following is said, which is also significant. All the rights in the Bill of Rights apply to inmates, save where justifiably limited in terms of Section 36 of the Constitution. Now, this court did not even bother to do a Section 36 limitation test to see whether, because obviously there must be cases where those rights may be infringed if Section 36 allows. And that's one of the principal errors committed, which we are quite sure that the higher courts would, at the very least, do a Section 36 analysis. They might come to one decision or another. That's a different matter. The fact is that the failure to apply Section 36 is on its own flies against the Constitutional Court authority.
But
let's come back then to the question of remedy, my lord. Oh, I'm sorry, my lord.
Yes. Shouldn't your argument be that the third respondent currently is serving his period of imprisonment, albeit outside prison?
Yeah, that's what I'm coming to.
The second point maybe this is what should have been raised by you during the hearing, that he is out on parole, not out of it's not his decision that he should have been released on parole. This issue has been exercising my mind. I'm raising it now so that other counsel could also respond to it.
Yes, ma'am.
We know that the third respondent is a sickly, is an elderly person with comorbidities.
As God.
And he deserves compassion and empathy.
Yes.
Despite what the Constitutional Court has said, the fact of the matter is his freedom of movement is restricted, which has an impact on his right to dignity.
Correct.
And having regard to the fact that he is not well, he is of advanced age, he deserves compassion and empathy.
Yes, that is correct, my lord. But yes, he certainly deserves compassion and empathy. And insofar as the order, that is exactly why I'm starting with the issue of remedy. Insofar as that order is punitive, one way or the other, to him as a person, and your lordship is quite correct, one has to take that, firstly, the issue that your lordship raises into account, that why would you punish him? Let's assume for a minute that there were irregularities in the granting of the parole, which we don't concede. Why would you punish him as if he gave himself parole, as if he released himself, as your lordship correctly points out? But as far as the issue being raised, your worship, my lord, that issue was raised acutely. In fact, ironically, it was raised by your lordship. The first question your lordship raised in questioning my learned friends was, but how can you say he's out there when he is serving a parole? Because that doesn't mean he's a free man like you and me or other people. And in argument, we reiterated the point that your lordship has raised. So I'm surprised if your lordship says it should have been raised, because it was raised by us and it was raised by your lordship. But your lordship, in his judgment, somehow abandoned that line.
Yes, can I come in there, Mr. Mpofu?
Yes.
What you are saying, in essence, is another court may arrive at a different finding. I think that point is made. Can we move to another point?
Thank you, my lord. Well, my lord, let me, if your lordship will please allow me just to round off on the remarks that your lordship made on the issue of mercy. The lordship, of course, is correct. That's why I was saying, whichever way you look at it, this is punitive. We know it's not a criminal court, but a punishment is a punishment. And your lordship knows the basic principles of punitive or sentencing is that it must be laced with a measure of mercy. But before anyone can even talk about mercy, one has to talk about the law. Compassion comes later. The law must be applied. What is parole? Parole is a form of correctional community type of service. And that is why it is clustered, even in Section 79. It says National Commissioner and so on may grant parole, which is ordinary parole, community service, and medical parole. All those things are of the same species. They are forms of serving a sentence. So the notion that when you are outside on parole, you are benefiting or you're just like any other person. As far as the law is concerned, remember.
Can I come in there?
I'm sorry, yes, Chief.
You must remember that at the time he was released on medical parole, he didn't qualify for ordinary parole.
Well, that goes to the other grounds, because for ordinary parole, yes, no, your Lordship is quite correct. I'm not talking about ordinary parole. I'm simply saying parole. Remember, the medical thing is just an adjective, but it's parole. It's like saying a red car.
Yeah, Mr. Mpofu, I accept that when you qualify for ordinary parole and you are released on parole, you are serving your sentence outside prison.
Yes, my lord.
I think we agree on that.
We agree on that, my lord. All I'm saying, I'm sorry, my lord. Your Lordship is not finished here.
The difference here is, at the time he was released on medical parole, not ordinary parole. He had not served enough time to qualify for ordinary parole. I think it's important that we draw that distinction.
Well, my lord, no. That distinction is a non-distinction. Let me explain, my lord. In the definition section of the Act, there is a definition of parole.
Yes.
Okay. It's parole. Whether it's medical parole or blue or yellow parole, is parole. So it says parole means a form of community corrections contemplated in Chapter 6. The point I'm simply making now is that by the legislature decided that parole is a form of imprisonment. It's a different form. So that I think you're quite right. We're saying the same thing. I'm just tracing it from the Act itself so that it's clear that we're not asking for compassion. We're simply asking for the law to be applied as it is in the section. So if compassion is applied, that may well be so. But the idea that parole is something else other than serving a sentence, which led, of course, to your Lordship's order of substitution to say that the period must not be counted. That flies in the face of the definition of parole. It flies in the face of the cases, other cases. In this division, there's a case which we posted this morning. I don't know if your Lordship saw it on a case of Dupree. We posted it on Case Line this morning. It was by
not deploy. I don't know. I haven't seen it, but I'm not referring to deploy.
No. I know the deploy case. No, there's a case. It's unreported, my lord. So if your Lordship hasn't seen it, then I will understand that. But it was by Mavundla AJ when your Lordship says it. It says something like this at paragraph 9. The applicant, like any other parolee, remains at all times a sentenced prisoner and has no right to parole, similarly to resist, in my view, the revocation thereof. And then it explains section 75 and so on. And then at paragraph 12 of that same judgment, it says, a parolee remains at all times a sentenced prisoner and has no right to parole. The National Commissioner has a wide discretion in deciding whether to release sentenced persons on parole or revoke the parole. And again, I'm not making the second point about the National Commissioner. I'm simply making the point that this court, your court, my lord, with respect, has found that a parolee is tantamount to a sentenced prisoner. But your Lordship and I are at one on this. And as I say, I'm not surprised because your Lordship himself raised this question with my learned friends at the hearing. And it's not clear in the judgment how your Lordship then came to the conclusion that the period, given that understanding, that the period should not count. And your Lordship, it comes, we don't want to re-argue the case. We simply want to say that your Lordship is quite correct, that the only question at this stage is whether another court on that specific issue would find that the definition of parole kind of prevents any order such as the one that was granted by this court of merely just ignoring as if the person is out there on holiday, when they are actually sitting under strict conditions. They have a parole officer, they cannot go here, they cannot go there, they must ask for permission to do this and do that all the time, which is the same as if someone was doing community service, as your lordship knows. You can't just say, oh, well, now I'm going to another province. If they are going to leave the magisterial district of Nkandla in this case, in the case of Mr. Zuma, he has to ask for permission from the Department of Correctional Services. Whereas and how can then a period like that, which is not normal life as suggested in the judgment, not be counted? That, apart from punishing the wrong person, is in its own just wrong in law with respect. Then, my lord, moving away from that point, in my respectful submission, that point alone that your lordship and I have just been discussing would entitle the application for leave to be appealed, because that's a serious question which needs to be explored by the higher courts. It might well be that your lordship is correct, that if you are on parole, you are not a prisoner. Despite
no, but Mr. Mpofu, the issue here is, and this is what I think the higher court would have to decide. At the time the third respondent was released on medical parole,
yes,
he had not served sufficient time to qualify for ordinary parole. Assuming I was correct in my finding that the parole decision was unlawful and unconstitutional, assuming that was correct, it would have meant that the third respondent is in custody.
Well, not necessarily, my lord.
Yeah, but listen to my point. My argument here is, if his release on parole was unlawful, he has to go back to prison because he didn't qualify for ordinary parole.
No, my lord. That's exactly the problem with the judgment. That's correct. Let's assume, my lord, that he was released on the 5th of September before qualifying for ordinary parole.
Lawfully released or unlawfully released?
Unlawfully. Let's assume he was unlawfully released on the 5th of on parole on the 5th of September, and then on the 6th of September, the court said. Then what your lordship is saying would be correct. It would, in either event, he would have to go back to wherever he was, whether it was hospital or the cell. There's no doubt about that. Your lordship is correct. But the issue in this case is whether, if that decision is taken 20 years later, when he has finished his sentence or he has passed the threshold for ordinary parole, whether the court can still act as if that the court was sitting on the day after. Surely that is wrong, my lord. Yes. That is really the nub of the issue. You can't.
I take your point. I think your point is well made.
As a court, please.
And I deliberately debated this with you so that we can get a response from other counsel. Can we move on, and then you'll have an opportunity to
reply? Yes. Yes, my lord, I'll leave the point of remedy altogether. Well, except to say that the order of substitution anyway, in our respectful submission, and we've made that point, I won't belabor it, does not conform with the 10 contest. But apart from that, I'll go to the merits. Everyone, at least everybody, including the court, my learned friends, everyone on either side accepts that this case ultimately is about interpretation of statutes. And that's why I was emphasizing the meaning of parole. Now, that's the only point that I wish to highlight, my lord, that your lordship, with the greatest respect, failed to address, let alone agree or disagree, the points that were advanced by the applicants. One was advanced by us, which was the delegatus point, which is that if there is a statute that has a general provision, such as Section 79, and also has a special provision, such as Section 75, then for a particular case such as this one, the special provision, Section 75, must prevail. What has that got to do with this case? If there is a specific section that says the National Commissioner, and specifically excludes all these other people, excludes the minister, excludes the parole board, excludes everyone, may grant parole for prisoners who are serving a sentence of less than 24 months, then that must be given effect to. Otherwise, those words are meaningless. It means that section is just there for decoration. Because otherwise, we should just all go to Section 79, which says any prisoner. Then why did the legislature have to put Section 75? That old maxim of law is to prevent that absurdity. Because by the legislature saying the National Commissioner may grant parole for persons under 24, clearly the legislature wanted to treat those persons in a different way to Section 79. And that is not surprising, my lord, because if you look at the whole of Section 75, it's actually littered with that. It says if you are 5 years, this and this might happen. If you are 7 years, this and this might happen. If you are in life, this and that might happen. If you are under 24 months, this and that might happen. In other words, the legislature, with its eyes open, wanted to create different differentiation between those categories of prisoners. So the question then, and your lordship raises the right question, because your lordship says in his judgment, well, that would then means that there is discrimination between different categories of prisoners. But that is not the test for discrimination, as it was said in Haxon. The test for discrimination is whether there is unfair discrimination, not whether there's discrimination. In other words, whether there's irrational differentiation. What is irrational about treating people who have lighter offenses and creating a particular regime for them, and those who may be serving life or whatever, creating a particular regime? That's perfectly rational. And that's the question that, in our respectful submission, in summary, we say another court might also, both the interpretation point as well as the rationality point, a higher court, particularly the SCA or the Constitutional Court, would find differently on that. But the problem is more serious than that, my lord. Your lordship has a duty to engage with those arguments and reject them or accept them. But these are serious arguments of interpretation of statute. So for the court not to even address them means that we are none the wiser as to whether the court accepted the argument or did not. And my lord, if I may refer to this is one of the most misunderstood issues about a judgment, that a judgment, after all, is communication to the public out there, particularly in a matter of public interest like this. It is communication to the parties as well. And the bedrock of a judgment is not a set of conclusions to say, well, you must just don't count the time or whatever. It is the reasoning that follows that conclusion. And this was said, my lord, in the Constitutional Court in the case of Parole versus First National Bank, 1999, 2 SA 667 at 671, as follows by Goldstone J. Says there is no express constitutional provision which requires judges to furnish reasons for their decisions. Nonetheless, open and transparent, why a case is decided as it is. It is a discipline which curbs arbitrary judicial decisions. Then, 2, it is essential for the appeal process, enabling the losing party to take an informed decision as to whether or not to appeal, or when necessary, seek leave to appeal. It assists the appeal court to decide whether or not the order of the lower court is correct. And finally, it provides guidance to the public in respect of similar matters. It may well be, too, that where a decision is subject to appeal, it would be a violation of the constitutional right of access to the courts if reason for such a decision were to be withheld by a judicial officer. What I'm saying, my lord, is that I'm not so much saying that your lordship should have applied this maxim, or even the other issue invoked by my learned friend, Mr. Parole, as to whether regulations can be used to interpret a statute that gave rise to them. But the mere fact that the court, in a case which is essential about interpretation of statutes, does not address two very important, very, very old canons of statutory interpretation which have been argued, rightly or wrongly, is in itself, with the greatest respect, a disservice to the parties, to the public, and to the appeal process. Because that court, when it deals with these maxims, will now be almost like a court of first instance without the benefit of your lordship's correct or incorrect reasoning on that issue. And that, with the greatest respect, my lord, is on its own a ground of appeal. And I'm picking up the most important ones because we don't have time. Then, my lord, there's the issue of separation of powers. This is very crucial. Your lordship, I won't bore you with the quotations from Batu Star. Your lordship is very familiar with all those, but they all come to this. It's not a complete prohibition, so I must not be misunderstood. But courts must be very, very reluctant to themselves step into the shoes of the executive. If an executive power is assigned to a minister or a national commissioner or whatever, that is an executive power. On the very sacrosanct principle of separation of powers, courts must be extremely reluctant to say, well, I saw an article in the Sunday Times, that means you are not sick. Because that, apart from encroaching on an area of executive power, is also placing the court in a position where it must make a medical decision. Let me make an example. One of the issues that your lordship raises is that doctor, I don't know which of the doctors, said that he's medically incapacitated instead of physically incapacitated. Now, that might be different in normal English, but how does your lordship know medically that physical incapacitation is not the same thing as medical incapacitation?
But Mr. What does the statute say? Because that's the language of the statute.
Well, that's the thing, my lord. One cannot be so rigid in applying the statute that if it uses a particular word, even if another word which means exactly the same thing is used, then we say, no, you're out, because you must use literally the very word. If the statute says it's a man, and you say, no, it's a male person, then you say, no, it's different. No.
Mr. Mpofu, let me make a quick comment, and then let's move on, because I think you have made your point. We'll hear what your opponents have to say. But I just want to hear you on this. You are saying if the statute talks of severe physical incapacity. I can't think offhand what it says, but it talks of a person who's severely
physically incapacitated, something like that.
And then you are saying, what did the doctor say?
It said he is that was not it said medically unfit. Your lordship said where he should have said medically unfit, or rather physically unfit. He said medically unfit. Now, the word medical means of the body. Physical also means that. Physical means of the body rather than of the spirit. So how can it be if you are physically unfit? That means there is something wrong with your body. So what can be the real difference? I mean, apart from the letters medically and physically, literally speaking, what can be the difference with whether as I say, it's like if the statute says the person must be a man, and then you say, no, he's a male. You can't say, well, that's not the word that is in the statute, because it means exactly the same thing. And the point I'm making is not so much that I'm right or your lordship is wrong. It's simply that your lordship is not qualified medically to make that determination as to whether medically unfit means the same thing as physically unfit. The applicants who bear the onus should have brought medical evidence from their own doctor to say, no, medically unfit means ABCD, whereas physically unfit means BCHD, whatever. Neither your lordship nor me
Mr.
can have this argument, the two of us. But
can I come in there? Your point is well made. Not in any way restricting you, but I ask that we move to
another point,
because we have many other counsel who are waiting.
No, of course, my lord. That point.
Remember, you said you needed 30 minutes to present your argument.
Yes, my lord. So
from now on, I'm not going to interrupt you. I'm just going to.
No, my lord. I know. Yeah. No, your lordship is quite welcome because it enriches the debate. Yeah. No, I'm saying, my lord, I've made the following points so that if I run out of time, I've made the remedy point. Your lordship and I understand each other on that one. I've made the separation of, or rather the interpretation point and the Mpahlele point. I'm now making what I call broadly the separation of powers point. And I'm kind of putting it on two legs. The one leg.
I'm sorry, my lord. I'm terribly sorry to interrupt my learned friend, but can I just point out that he's now had 35 minutes already. So I don't know whether he's cutting into his colleagues' time or whether we are just going to abandon the agreement as to time.
Thanks for the point. I think maybe I took some of his time. Mr. Mbofu, how much time do you need to sum up?
I can wrap up in about 5 to 6 minutes, my lord.
Okay.
The interruptions were not. They are very welcome, and I'm sure your lordship has got his own clock. We don't need counsel for the DA to assist us. But I need about 6 minutes.
Mr. Mpofu, can I ask that you wrap up your argument in the next 5 minutes?
So I will, my lord. I will. Yes. So what I was saying, my lord, is that the one leg of the separation of powers point is this issue about expertise, medical expertise. We've made that. I'm not going to revisit that. But the other point, the bigger point maybe on separation of powers is the fact that once the legislature has designated a particular official who works in that space, who understands that space, as was said in this case that I just read by Mavundla AJ, then the court must not itself offer a view easily. Of course,
you've made that point, Mr.
Yes. Yeah. So it's a two-legged point. And the point again that I'm making, my lord, is that another court surely might agree with the Batu Star and all those other authorities. Then, my lord, the final point I wish to make is, and I will make it very briefly because my learned friend, Mr. Mpahlele, also picked it up, is that even if you look at literally, your lordship says that, let's look at paragraph 29 of your lordship's judgment. Your lordship says, on the same day, 20 days after the third respondent was taken into custody, Dr. Mafa applied for medical parole on behalf of the third respondent. In the application, says your lordship, Dr. Mafa stated that the third respondent was suffering from a terminal disease or condition that is chronic and progressive. This is your lordship speaking. He says Dr. Mafa stated that the third respondent, Mr. Zuma, was suffering from a terminal disease or condition that is chronic or progressive. Those words are taken directly from section 79. In other words, Dr. Mafa said that he is suffering from a terminal illness. However, yourself, the same judge at paragraph 62 says, Dr. Mafa, in completing the medical parole application, does not state that the third respondent suffers from a terminal disease or condition. So where are we? Does Dr. Mafa state that he suffers from a terminal condition, as your lordship correctly points out in paragraph 29, or does not, as your lordship, the same person, says at paragraph 62? Now, if he does, and again, I'm not making the point. The point I'm making, if the higher court agrees with your lordship's assertion in paragraph 29, within our respectful submission is correct, then of course, what flows from that is that at least that doctor. So that means your lordship's finding that none of the doctors have, which your lordship makes, I'm sorry, my lord.
I think the point is well made.
Yes, as a court pleases. So, my lord, just on those broad basis, let alone issues of standing and mootness. And all I want to say, my lord, is that the mootness point, of course, is related to the remedy point, because your lordship is quite correct. If indeed he does qualify for ordinary parole, then the mootness point might come back. If your lordship is correct that the period should not be counted, then of course, so there is that relationship, which another court might also find that the mootness point then become, if the court is with us on remedy, it might well be that the mootness point is still alive, as the court pleases, my lord. Those are our submissions, my lord. There are many other grounds. Your lordship has seen our application and the heads. Because of time, I will confine to those.
Thanks, Mr. Mpofu. Mr.
My lord, I'm so sorry. I'm sorry, my lord. We have said that your lordship should refer the matter to the SCA. I promise to come to that issue. Alternatively, to the full court. I know that the National Commissioner has got the different configuration. Maybe after hearing what my learned friends have to say, I'll deal with that in reply.
Yes, thanks, Mr. Mpofu. Mr. Mpahlela?
Please, Your Lordship.
How much time do you need, Mr. Mpahlela?
My Lord, I'll try and stick to the time that was agreed in chambers.
Yes, I'll appreciate that. I'll also try not to interrupt you.
May please, Your Lordship. Firstly, my lord, I think, we stand by all that is said in our heads of argument in our application for leave to appeal. But however, I just wanted to pick up on some few pertinent issues. Firstly, I would like to pick up on what was said by my learned colleague in relations to the fact that medical parole, like any other parole in itself, it's a system of community correction. In that, and we've made reference to that in our heads of argument to the case of Parole versus the Minister of Justice and Correctional Services, where the court held that parole is a form of punishment which is served by an inmate within a system of correctional of community corrections in terms of Chapter 6 of the Act. And if that is the correct legal position, my lord, my submission is that if now we're having a situation where it is said that the third respondent himself, period which he served, outside the prison should not count, that in itself we submit would amount to double jeopardy. And secondly, we submitted that, it cannot be said that he released himself. He didn't release himself. He was released by the National Commissioner, and therefore he was not party to any illicit behavior, and therefore he cannot be punished twice for that. Now, in relation to medical parole, my lord, there are no times for qualification for medical parole. What is only required of an inmate or an offender is that he must suffer, the kind of illness, he must be terminally ill, or that he must be incapacitated in such a manner that he's not able to perform his daily activities. That's all that is required. While there are time frames that are required for ordinary parole, that is not required in relations to medical parole. So he can be determined at any time. Having said that, my lord, I'll now go back to our submissions in relations to what Your Lordship has made a finding on, both on fact and law. Firstly, my Lord, we would like to deal with paragraph 44 of Your Lordship's judgment, where Your Lordship says that that the offender's trusted medical practitioner no longer make a diagnosis of a medical illness or a physical incapacity. Now, we would want to refer Your Lordship to the provisions of the Act. Because now the Act in terms of section 79 2A says that an application for a medical parole shall be lodged in a prescribed medical manner by a medical practitioner or a sentenced offender or a person acting on his own behalf. So in the event that it is made by a sentenced officer, obviously there's a need that it should be accompanied by a medical report. But of importance, my Lord, is reference to is what is said in section 79 2C, which says that the written medical report must include, amongst others, the provision of a complete medical diagnosis and prognosis of a terminal illness or a physical incapacity from which the sentenced offender suffers. Now, we have a medical application that has been made by a medical practitioner, and that particular report then must then contain a complete medical diagnosis and prognosis of the terminal illness or a physical incapacity. So on that basis, my Lord, we submit that it was Your Lordship erred in paragraph 44 when it says that there's no need that in terms of the new regime that it said the medical advisory body, an independent expert comprised of 10 medical appointed by the has the impartiality and independence made a medical determination whether or not an offender is terminally ill or suffering from. So we submit that it is not the medical parole and advisory board that makes a diagnosis. A diagnosis must be made by a medical practitioner that has assessed and examined the offender. Now, if one were to look now on section 79 3A, my Lord, and that is the one that deals with what is it, the role of the medical parole and advisory board, and that's the one that gives the extent of what is it that he needed to do. And I'm saying this by making reference to the Act, my Lord, because Your Lordship, in his judgment, looked at the regulations, and that's where we came up with that argument that Your Lordship erred in utilizing the regulations in order to determine the meaning of the Act itself. By so doing, we have a situation where the tails wags the dog. And if one were to look at 79.3.8, it says the minister must establish a medical advisory board to provide an independent medical report to the National Commissioner, Correctional Supervision and Parole Board, or the minister, as the case may be, in addition to the medical report referred to in subsection C. Our submission is that now this is the role of the medical parole and advisory board. It only provide an independent medical report to the National Commissioner in respect of this matter. It doesn't, as Your Lordship has ruled, makes a determination or a prognosis, and the fact that Your Lordship ruled that such a recommendation is final and binding, we submit that, my Lord, that is a misdirection on the basis of what it says here. And I'm going to deal with the case of that Your Lordship has referred to as the authority for the submission, the case of the Kimberley Junior School, which Your Lordship has referred to as the authority for the proposition that the recommendation which is made by the parole board it's final and decisive. We said that is not correct, madam, for the following reason. Now, if Your Lordship could look at the case of the Kimberley Junior School versus the head of the Northern Cape Education, here it is the Act, that is the Employment of Educators Act, Section 6.3, which says the following. It says, any appointment, promotion, or transfer to any post of an educator established of a public school may only be made on the recommendation of the governing body or the public school. Now, what this Act is saying is now saying the recommendation that an appointment could not be made unless there's a recommendation. And this is an Act as opposed to the regulation. Because now in the Correctional Services Act, all that is being provided for is the fact that the medical parole board advisory board would have to provide an independent report. So now, when the National Commissioner has to determine, in the exercises of his own discretion, whether to grant or not to grant parole, he will have to look at all the reports. That is the report of the medical practitioner, of the offender, also including the independent report of the medical advisory, medical parole and advisory board. So this is an additional report that the National Commissioner would have to look at. That then brings us to the conclusion that the person that makes a determination on whether to grant parole or not parole is not the medical parole and advisory board. It is the National Commissioner in terms of the section that we are relying on. So we are submitting that after all, the Kimberley Junior School is not an authority for a proposition that the recommendation itself is final and binding. That's the first point, my lord, that we needed to do. We move into the and that will deal with the point that is in paragraph 55, 57, and 58 of your lordship's judgment. Because in paragraph 55, your lordship says, suppose the recommendation of the medical advisory board is positive. In that case, the National Commissioner must, from a correctional services perspective, decide whether, despite being found to be terminally ill, there is still a risk of reoffending or that the offender cannot be cured for properly outside the prison as stipulated in section 79B and C. What your lordship is saying that is that if the recommendation is positive, it is only then that the National Commissioner should consider section 79, 1B and C. We're saying that the court misdirected itself even on that point, Malo, because as the person that is having the discretion to determine whether to grant medical parole or not, the National Commissioner must not only consider the provisions of section 79, 1B and C, he must also consider the provisions of section 79, 1A, because he must also check and determine as to whether, under the circumstances, is the offender terminally ill or not. You must still do that determination before moving to B and C, irrespective of whether the recommendation is positive or not. That's another point. And on paragraph 57, your lordship says, in summary, the board and not the doctors treating an offender, as it was in the case previously, decides if the offender is terminally ill or severely incapacitated. If its recommendation is positive, the commissioner must then decide whether section 71B and C are satisfied. We said that is not correct, my lord, because that would amount to rubber stamping. And if the legislature intended that it should be the medical parole, medical advisory parole board that makes that particular determination, the legislature would have clearly and specifically stated so, and it did not. Because if one looks at the legislation itself, it should be the National Commissioner and not the board. And on paragraph 58, my lord, your lordship also made the following finding. The recommendation of the board as an expert body established to provide an independent medical report on whether an offender is terminally ill or physically incapacitated is ordinarily decisive and binding on the commissioner. The commissioner does not have a medical expertise to overrule the recommendation of the board. My lord, it is quite clear that if that was the intention, we would have made it very clear, and we've made that distinction to say, in respect of the Kimberley Junior School, there it was very clear that the discretion of the head of department was circumscribed, because he could only make the appointment if there's a recommendation. But that is not what the wording of section 79. 3A says, because 79.3A only says that after all, it shall provide an independent medical report. My lord, I want to move to the next point.
How much more time do you still need, Mr. Mphahlele?
My lord, I just wanted to let me just see. So far, I think I've used less than 15 minutes of my time, my lord.
Okay.
I've just only less than 15. I still need another 15 minutes just to wrap up one or two things. My lord, I just want now to deal with the page 29. I just want to pick up those that I think are of critical importance. Under paragraph 91, your lordship says made the following finding: the kind of challenge presented in this matter is that the Constitutional Court has already determined that a 15-month direct imprisonment was the only just and equitable order to make under the circumstances, and has rejected the other lesser form of punishment. Now, my lord, we deal with that in page 32 of our heads of argument. We made the fact that the court has sentenced an offender to a direct imprisonment does not in itself, my lord, preclude the offender concerned from being considered for parole. And in this instance, medical parole. Because the Constitutional Court, my lord, has exercised its powers by sentencing the third respondent to incarceration, consequences upon which he was handed over to the Department of Correctional Services, which in turn is sanctioned by the Correctional Services Act to deal with inmates under its control within the confines of the law. And once an offender is sentenced, the Correctional Services Act provides that the National Commissioner has the discretion to determine on whether the offender should be granted medical parole.
Mr. Mpashele, I don't think there's a dispute about that. If a person qualifies for medical parole, even if the Constitutional Court has imposed a direct sentence of imprisonment, in my view, the question here is, do you qualify? If you do, you are entitled to be released on medical parole. So this depends on whether the parole decision is lawful or not. If the parole decision is lawful, a patient who's terminally ill has to be released on medical parole. I don't think there's a dispute about that. I just thought I must clarify this, that if you qualify for ordinary parole, yes, you must be released. If you qualify for medical parole, you must be released. The issue here is, if the parole decision was unlawful and unconstitutional, then it would mean that the release of the third respondent on medical parole is also unlawful.
In this, my lord, and we submit that your lordship came to the conclusion that it is unlawful and unconstitutional because your lordship moved from the wrong premise that the recommendation by the Medical Parole and Advisory Board is final and binding. And we said the legal position is not that, my lord. The legal position is that it only submit a report, and it is that report of the parole board that has to be considered together with other reports. And we then made a submission that the report of Dr. Maspa and the report of Dr. Mpatso indicated, and that in itself, that the offender complied with the requirements of the law, and that's not unlawful and unconstitutional.
Thank you. The point is well made, Mr. Mpashele.
And your lordship, in his determination or in making his finding, looked at the wording that was used in the report of Mafa and the report of Dr. Mpatso, without interrogating all the necessary information that was before the National Commissioner when the National Commissioner made the decision on whether to grant medical parole or not. And the lordship was not even in possession of all that information, because there was some information that is with the South African Medical Health Services that was not before the National Commissioner. I mean, that was not before this honorable court. And the report, some of the reports were redacted. That was before the honorable court. And on that basis, the honorable court was not in a position to make an informed decision based on all the medical evidence that was before it, and was not even in a position to interrogate those, because it didn't have them before itself. So therefore, the decision to substitute the decision of the National Commissioner with its own decision, we submitted this. It is a misdirection, my lord.
Yes, but Mr. Mpashele, the Parole Advisory Board has all the reports, even unredacted report, and it came to a conclusion that the third respondent does not meet the requirement of that. That's their finding.
That is their finding, my lord. And the finding is not final and binding, because all that they did to do is to submit their finding. And the National Commissioner does not only has to accept what the parole board is saying, he must also determine on the information that was before the parole board as to whether in the view of the National Commissioner, the parole should be granted or not.
Yes.
So that's the point that we're making.
Yes, thank you. The point is well made, Mr. Mpatlela.
Yeah. And my lord, I just wanted now to address, because of the time constraints, the point that we're making in terms of compelling reasons. We submitted that, apart from those reasons that we've demonstrated, that there are reasonable prospects of success on appeal, that this matter presents a quintessentially case for a compelling reasons as envisaged in Section 17(1)(a)(2) of the Superior Courts Act, as to why this matter should be heard by an appeal court, in that the decision of the Court of Appeal will bring about certainty, my lord, in the correct interpretation of Section 79, read with the provisions of Section 75, 7A of the Correctional Services Act, and the regulations promulgated thereafter. And secondly, my lord, the interpretation of legislation and regulation promulgated thereunder is by its nature eminently appropriate for the attention of the appeal courts. If this court has erred in its approach, as it appears that it is indeed has done so, then the future litigants will be entitled to the benefit of this court's view on the issue. And the matter also involves a discrete legal issue of public importance that might arise in the future and require the aggregation of an appeal court for guidance and certainty purposes. And as a result, we submitted that the application for leave to appeal should be granted. Now, my lord, I just wanted to make the last point. This Medical Parole Advisory Board made a decision that the third respondent was stable. That's all that it says. It didn't say that, after all, he's not terminally ill. He didn't say that, after all, he's not incapacitated to a point that he cannot do his daily duty. He said he was stable.
They said he does not meet the requirement of the Act.
He said he does not meet the requirement of the Act. We're not quite sure which requirement are they referring to, but they said he was
79(1).
My lord, that is not what they're saying. They didn't say he didn't meet the requirements of the Act. We don't know whether they talk about all of them. And we are saying they only say he's not stable, and that doesn't mean that he has been cured. Because even if you are stable, does not mean that, after all, you are now in a position going forward to no longer terminally ill. And on that basis, my lord, we submit that, after all, a case has been made out that for leave to appeal, and we submit that the application for leave to appeal should be granted.
Thanks, Mr. Mpatlela. Who's next, Mr. Yami?
I think it would be me next, Justice Matajane. May I proceed?
Yes, you may proceed.
Justice, I have 20 minutes, so I'm going to be as succinct as possible. The test the parties are agreed for leave to appeal in terms of Section 17(1)(a) Roman 1 is now more stringent than it was before. This court has held in the case that we cite in our heads, let me just get to it. Basenzi, we reference it in para 6 of our heads to paraphrase the case, that there must be a measure of certainty that the appeal court would find for the applicants or the appellants. And I emphasize the words a measure of certainty and would, not as before, might. Now, that sets, we submit a high bar, and that bar is not met by any reasonable reading and consideration of the two applications for leave to appeal. In this regard, we point out, Justice, in para 10 of our heads, and I trust you've seen our heads, Justice.
Yes, I have read your heads.
We make the point in para 10 that the DA challenged the medical parole decision on 5 discrete and disjunctive grounds, in other words, separate grounds. And we list them. I don't have the time, I'm not going to run through them. We list them in para 10. And we submit that there are no prospects, let alone reasonable or with a measure of certainty prospects, that an appellate or an appeal court would find against the DA on each one of those. And we emphasize and make the point, Justice, that the DA only needs to be upheld on one of those grounds for the decision to be set aside and for the appeal to be dismissed. So as a principal reason for opposing the application, we submit that the court will bear that in mind. Now, my learned friend Mr. Mpofu, and to a lesser extent, counsel for the Commissioner, emphasized the remedy point, and the court debated that to a large extent with Mr. Mpofu in the submissions that he made. Now, although the DA did not take the remedy point, in other words, the specific point, which is the basis of the complaint, namely that the time served while on medical parole should not count for the sentence, that point was taken by the Helen Suzman Foundation. The court did accept the argument, and it's incorporated in your order, so we are entitled to defend it, which we do. Now, our learned friends, we submit fundamentally in their submissions and the authorities they quote to you, such as Sonke Gender Justice, which Mr. Mpofu quoted. This case, Justice, has nothing to do with the rights of prisoners. That is a very old and very sacrosanct principle which long preceded the advent of our Constitution, that prisoners retain all the rights, albeit before the Constitution it wasn't constitutional rights, which they had before incarceration, but for those that are necessarily or reasonably constrained by the fact that they are prisoners. And we have no quibble with that as a point of departure and as a principle. But with great respect, to start on that premise and to couch the debate in that framework is fundamentally incorrect and misleading, because that is not the issue. Mr. Zuma, while incarcerated, had full access, as we know from the record, to the best possible medical care in prison. He had the assistance, he had nurses assigned to him, he had the assistance of medical practitioners from the military health service, and he was being optimally managed in prison. Perversely, now that he's been released on medical parole, he has been released to Nkandla in the care of his wife, who has no medical training or expertise. Nkandla is many, it's not famous in way, it's so his condition, the conditions under which he's been incarcerated, or not incarcerated, the conditions under which he's now serving a sentence, albeit on medical parole, are suboptimal compared to the conditions that he was serving them under while in prison. And we also know that, I think the record indicates this, for the entire period that he served his sentence in prison, he in fact was in prison for less, I don't think even one day. Upon admission, he was immediately put into the hospital section of Escort Prison. Shortly afterwards, I don't have all the facts, but they are clear from your judgment and the record, he was transferred to a facility, I think it was in Pretoria, and thereafter he was released on medical parole. So he's had optimal medical treatment, which is not the case now. So the correct framework of the remedy order that you made, namely that he served at the time that he's been out unlawfully on medical parole, and we submitted it is unlawful for the reasons in your judgment and in our application and the other applications. Your order that time not count toward time served was an order that once you found that there was an unconstitutional act on the part of the Commissioner, you were entitled and in fact obliged in terms of 172(1)(b) to make. And that's how you construct it as we understand it, your order. There's a second basis for the order you made, and that is just and equitable remedy, which has to be made in terms of PAJA when you find an administrative action is reviewable. So on those two legal bases, and we've dealt with all the authorities in our previous heads, Justice, that order we submit was an order you were entitled to make. And we are not to be understood as saying that, and as you correctly with respect pointed out at the commencement of the debate with Mr. Mpofu, we accept, and I believe we made that submission also in the main arguments at the hearing, that we are dealing with a 79-year-old sickly individual. No one says that he is in the greatest of health. We accept that. That's what the medical parole board says. But what's beyond any doubt, Justice, is that the order you made is grounded on the facts, and I'm going to deal with those briefly in a minute, and was not and cannot be understood as being a punitive order. And the court, with respect, should not substitute legal reasoning, which is what your judgment contains, for unwarranted sympathy for the position in which Mr. President or Mr. Zuma finds himself. The position he finds himself in, Justice, is one of his own making, and we accept that he did not author, although we do make the point very strongly, and that's one of the 5 grounds upon which we attack the granting of medical parole. We make the point that indisputably Mr. Zuma was treated differently to any other prisoner within the South African correctional services system. And secondly, we submit, and we submitted, that there are very strong grounds to believe that he was treated differently because of his previous position, and thus there's the issue of bias, which we raise pertinently, and which is not challenged in either of the applications for leave. So the point, Justice, is this was not a punitive exercise by the court. It was an exercise that the Constitution requires you, and PAJA requires you to undertake. And you undertook that decision logically and legally and correctly, we submit, on the facts before you. And it is not a basis to grant leave to appeal merely because you may personally, and I may personally, have sympathy for Mr. Zuma. That's not a legal ground for granting leave to appeal. I emphasize again, there must be a measure of certainty that an appeal court would have found for the applicants or the appellants. And we submit that there are no such grounds. If I could just briefly deal with the substitution point, which is also raised, we submit there's no basis for a court of appeal interfering with that, for the simple reason that unlike our learned friends, we submit that TRENCON, the considerations in TRENCON were present here. If the court accepts the correctness of your reasons, which we submit the court obviously must and should, then there is no other possible conclusion to which Mr. Or the new commissioner could have come had the matter been remitted. Section 79 is the only pathway to medical parole, as we argued earlier. I'm not going to re-argue that. We've heard no new arguments which we submit persuade an appeal court to disturb that finding. It's the only possible finding. Section 75 identifies the actors and provides no basis for the criteria which must be taken into account for medical parole. That is squarely dealt with only by Section 79. And you correctly analyse in paras 75 to 85, we submit, of your judgment, Justice Matijane, you analyse the legal position in paras 75 to 85, and I emphasise your reasoning at paras 81, 83, and 85 of your judgment. In fact, if I can just point out that in para 81, you say Section 79 applies irrespective of who the decision maker is, and we submit that is entirely correct on an analysis of the legislation. At para 83, you make the point, which none of our legal friends have dealt with, that Dr. Martha applied for medical parole under Section 79 of the Act. The application form is headed medical parole application in terms of Section 79. In para 85 of your judgment, you reference para 47 of the answering affidavit by the Commissioner, where the Commissioner himself confirms that the application was lodged in terms of Section 79, 1 of the Act, and Regulation 29A, 3. And then you quote from Regulation 29A, 3. So it hardly lies in the mouths of the applicants for leave to now try to get out of the understanding, the common understanding of everyone, and the factual and legal position that this application was in fact made in terms of Section 79. The obvious reason they want to get away from that is because Section 79, if not complied with 79(1)A, the Medical Parole Board does not give a positive recommendation. That's the end of the road, as I argued before. And that is the reason that they now try to rely on 75. But that's a dead end for the reasons we advanced earlier in the main hearing and for the reasons you found. One last point. Counsel or the Commissioner reiterated the argument previously made this morning that you erred in using the regulations to construe the Act. With respect, we argued, as I recall expressly, that that was not what the argument was. Our argument was not that. And we submit on a fair reading of your judgment, that's what you found. You did not fall into the fundamental error of using the regulations to interpret the Act. What you did, my Lord, is to apply the regulations, which are there on the statute book. And remember that our submission earlier in the main hearing was that these were not ordinary run-of-the-mill regulations, administrative regulations. These regulations had to be placed before Parliament to be accepted. And Parliament had to approve these regulations. So these are special species of regulations which have the imprimatur of Parliament. But more importantly, if there was an issue that the present applicants had with Regulation 29A3, that should have been challenged squarely, and it could have been defended then. But they haven't done so. So the regulation stands, and it's not a question of interpreting the Act in terms of regulations. It's applying both the Act, properly construed, and the regulation, which is extant and on the statute book. With regard, Justice, to, I'm not going to deal separately because I don't have the time, and also because we have already dealt with it. We submit comprehensively in our main heads, and it's dealt with in your judgment. I'm not going to deal with the merits to any extent. We stand by our principal submissions in that regard. With regard to the facts, as I promised to get to, we deal with this, Justice, in paragraph paragraph 27. In paragraph 26, in our heads that we file for purposes of this application, we say Mr. Zuma claims that Dr. Mafa, who applied on behalf of Mr. Zuma for medical parole, asserted in the application that Mr. Zuma suffers from a terminal illness. Now, our learned friends have referenced paras 29 and 70 of your judgment. They say this contradiction.
You are fading, Mr. Jami.
I'm sorry, Justice.
Yeah, you are fading.
Fading.
Where you properly, yes.
I'm on maximum volume. Can you hear me, Judge?
Yes, you may proceed.
As the court pleases. There was a submission that there's a contradiction between paras 29 and 70 of your judgment, inasmuch as in 29 you say that in the second sentence, in the application, Dr. Mafa stated that the third respondent was suffering from a terminal disease or condition that is chronic and progressive. And then they say, well, in para 70, you say that if I could just get to it, Justice. In para 70 on page 23 of your judgment, you say the third respondent claims that he suffers from a condition which carries significant risk to his life. Nowhere does he claim to be terminally ill or physically incapacitated. We submit that on a fair reading of the judgment, you were under no stage under the impression, or did you make a finding, that Dr. Mafa stated that the third respondent was suffering from a terminal disease or condition, leaving aside the words that is chronic and progressive in para 29. So while the wording in 29 may be slightly out of kilter with the requirements in section 79(1)A, we submit on a reading of the judgment as a whole, you find that the doctors did not clearly or at all assert that the requirements of 79(1)A were met, and you also find, as we know, that the Medical Parole Board found positively that they were not met. And that was the basis of your judgment. Now, if we can go to what we say in para 27, we in fact insert in the heads an extract from the application for medical parole. I don't know whether you have our heads in front of you, Justice.
Yes, I have your heads.
I ask you to just go to para 27 because it'll make it easier to follow the argument. This is a direct from the relevant document being the application for medical parole and the crucial answer for Dr. Marfa in this regard. And this is the basis, the linchpin upon which the argument is made that there was such an assertion as to bring Mr. Zuma within the confines of Section 79(1)A. And we submit simply it doesn't hold water. The question D is the offender suffering from a terminal disease and emphasized or, in capitals, condition which is chronic, to which he answers yes, is progressive, yes. And then the third question, has deteriorated permanently or reached an irreversible state. We emphasize permanently or an irreversible state. His answer is destructive of Mr. Zuma's case and the Commissioner's case. His answer is not yes, but deteriorated significantly. Now that is a conscious decision, clearly, by Dr. Marfa to negative the question, or rather to negative the notion, that the deterioration is either permanent or irreversible. He deliberately does not say yes. Had he said yes, we would be dealing with a different factual matrix. He says deteriorated significantly. Now, what is also important in this regard is the definition, which follows immediately at the foot of the page, of a terminal disease or condition. And that is the wording, as you know, of at least the first part, terminal disease, is the wording of 79(1)A. And that is defined for purpose of this form as a terminal disease or condition is a condition or illness which is irreversible, with poor prognosis and irremediable by available medical treatment, but requires continuous palliative care, and will lead to imminent death within a reasonable time. That is what Dr. Marfa should have asserted is the position with Mr. Zuma in order to bring him justice within 79(1)A. And I say that cognizant of the fact that 79(1)A has a second provision, which is so physically incapacitated so as not to be able to meet the requirements of daily life. And we submit that on proper evidence that was placed before the court, Mr. Zuma doesn't come home on that second leg either, because we know he's out there moving around, addressing supporters, meeting supporters, etc. So he simply is not on the record, quite apart from the fact that nowhere is it asserted that his condition is physically such that he cannot take care of the daily needs of life. Apart from the fact there's no such assertion, the objective evidence properly before you, Justice, is that that's not the case. On the first leg, with regard to having a terminal disease, we've dealt with that at length in our previous submissions, and I've just pointed out to you what the correct factual position is. So with great respect, on the merits and on the facts, the applicants cannot come home either. Lastly, Justice, I think I've made the submissions I wish. Yes, just to round off the point, in paras 61.3 and 61.4, we make, of our previous heads, Justice, we make the following points. The closest Mr. Zuma comes to meeting the conditions of 79(1)A is from a condition which carries significant risk to my life. And we make the point, the obvious point, that a condition that poses a risk to his life, even a significant risk, is not a terminal illness, nor does it imply that the person is incapacitated. And then 61.4 we say, we make the point, which is not without significance, Justice, that the only time that Mr. Zuma in his affidavit uses the phrase terminal illness is in this sentence. The DA would gloat endlessly if it was in possession of written confirmation that its formidable political foe was sick with a terminal illness. Now that is not an assertion that he is so ill, Justice. It is a hypothetical And clearly he doesn't state here that I, in fact, am. So for all those reasons, Justice, we respectfully submit that there are no prospects and that the court should be wary of its sympathy, which you've expressed with respect this morning for Mr. Zuma, for that being substituted for legal logic and basic principle in order to grant leave when leave shouldn't be granted. If leave is to be granted, because we all know, as a racing certainty, Justice, that if you refuse leave, there will be applications to either the SCA or the Constitutional Court for leaves, for special leave. If those courts are moved to accede to the arguments that are made before them and grant leave, so be it. But that does not mean that this court should ignore the clear legal constraints that govern an application for leave at this point before you and grant leave out of sympathy or for some other reason not contemplated by Section 17(1)(a) of the Superior Courts Act. Those are our submissions, Justice. Unless there's anything else, we submit with respect that the application should both be refused with costs of £2. And with regard to the issue of if leave were to be granted on one or other basis, and in respect of one or other part of the judgment, one or other order rather of the judgment, then were that to be the case, we respectfully submit this is an obvious case where leave should go to the SCA and not to a full bench. Sorry, there's one last argument. I'm sorry, Justice. I'm not going to deal with the preliminary points because they're set out in our initial heads in detail. We submit that no new arguments are made that will make an appeal court reconsider or overrule you on the mootness or the urgency or the locus points. I understand that there is a recent full bench judgment from the Gauteng division which makes it clear that there is absolutely no basis. The same argument that is being advanced here, but I believe the same counsel was roundly rejected by the full bench. Mr. du Plessis, I understand, will deal with that. But the one substantive submission about the preliminary points I do want to make relates to urgency. Justice, it can never be the case that, and we know that the question of urgency is in issue between the parties. We brought the application as a matter of urgency, as did the other applicants. Urgency was disputed. But the moment you gave judgment, in fact, on the same day, Justice, Mr. Zuma applied for leave, demonstrating that he himself and his lawyers considered the matter urgent. The National Commissioner followed suit a day or two later. But the simple point I want to make, and I don't have authority for it, but it's a point of logic and basic principle, is that where urgency is in dispute in a matter, an appeal, which is inter alia, an application for leave to appeal, and thus an appeal, which is inter alia based on the question of whether the matter was urgent, because that's one of the grounds that they seek leave to appeal on. If such an argument is being made, which it is, then quite obviously, Justice, the appeal proceedings must be urgent and must be dealt with urgently. And you quite correctly, with due respect, convened this hearing within days of the applications precisely because you consider the matter urgent. Our learned friends initially tried to have the matter heard only in February, and then they reconsidered their position, quite correctly we submit, and have now agreed that the matter, these applications be heard urgently. And similarly, any appeal which follows from this judgment should be dealt with urgently. So the question of urgency, if not, or rather the question of urgency, if raised in proceedings as it has been, any subsequent appeal, in order to avoid justice, the question of urgency becoming a brutum fulmen must itself be dealt with urgently, the subsequent appeal. And that's just as a matter of logic and basic principle. Those are our submissions. We say that two applications should be dismissed, Justice, unless there's anything else that you wish to raise.
Thanks, Mr. Chairman. Mr. du Plessis?
For business.
Thank you, my lord. We heard from our learned friend, Mr. Mpofu, that the prospects, he said, are overwhelming. We, with respect, disagree with him. We think they are underwhelming to the point of vanishing. And I'd like to submit to my Lord why we say so through what we contend are five, what we respectfully submit are elementary errors committed by our learned friends. The first elementary error, my Lord, starts right at the beginning, and that is that they don't properly, with respect to them, understand the test for an application for leave to appeal. It starts early in the application for leave to appeal at paragraph 2 by Mr. Zuma, where the test they stipulate is whether there might be prospects of success on appeal. Sorry, my Lord, my sound is breaking up a bit. Can you hear me clearly?
Yes, I can hear you. I would like
right.
to know if there's a problem.
Good. Let me repeat that sentence, my Lord. It was jamming my end. So in their leave to appeal application, paragraph 2, they reiterate the old test, whether there might be prospects that another court would differ. But my Lord, of course, that's not the case. The test has been significantly heightened, and I learned from Mr. Jamie has already highlighted that. I'd simply stress that my Lord will have seen from the Supreme Court of Appeals decision in Mkita that the court, and we've cited this in our heads at paragraph 11, the court has stressed this new and higher test under the Act, and it has said that a mere possibility of success or an arguable case or one that is not hopeless is not enough. And we say, with respect, my Lord, this is the test that our learned friends do not meet. And they also fail to understand the test with respect to Mr. Mphalela, who was arguing that in any event, he pointed out, he says that there are compelling circumstances, as he put it, for why under Section 17 an appeal court should hear this case. Well, my Lord, that's not enough either, because the Supreme Court of Appeal has stressed that in determining whether there is a compelling reason under Section 17 to entertain an appeal, the merits remain vitally important, said the court, and are often decisive. And we've quoted that case, my Lord, for, my Lord, it's Karatko, a decision of the Supreme Court of Appeal in 2020. So, my Lord, that's the test. And our learned friends, with respect, want a lighter test for them, but that is not the lighter test that prevails. It's the higher test, and they don't overcome it. The second elementary mistake our learned friends commit, my Lord, and in particular for Mr. Zuma, is they continue to contest standing in a case where just a few weeks ago, my Lord, the full court in this very division has convincingly and overwhelmingly found against that point. So we see that it hasn't been argued orally, but it may well be argued in reply by our learned friend, Mr. Mpofu. So I'm going to deal with it quickly, my Lord. And just to highlight that in their leave to appeal application and in their heads, Mr. Zuma continues most remarkably to contest the applicant's standing, my Lord, supposedly because he says that my Lord erred in not taking into account the applicant's motives in bringing the case. Well, my Lord, of course, there was no evidence of any such motive. It was just scurrilous argumentation by Mr. Zuma through his counsel. But there's a much more elementary and telling mistake, my Lord, and that is that it flat ignores that just a few weeks ago, the same argument was run and lost before a full court of this division, my Lord, and we've cited this case in our heads of argument. It's Freedom Under Law versus Schlope. It's a judgment of the 29th of November, my Lord, and per Sutherland DJP, Ledwaba DJP, and Her Ladyship Justice Victor. And our learned friends are well aware of the case, my Lord, because Mr. Masuku, although he did not argue orally on the day, is the lead counsel in that matter for Judge Schlope. And in that case, too, Mr. Masuku's team contended that Freedom Under Law had no standing to be involved in the application. And in that case, too, it was argued that Freedom Under Law should be declined standing because of its supposed motives in criticizing Judge Schlope's conduct, my Lord. But there, the full court, per the judges that I've just referenced, my Lord, rejected the argument, and they did so with costs on the basis that it had absolutely no merit, my Lord. The third elementary mistake, my Lord, goes to the heart of the case, and we've heard some debate about it through our learned friends today, and it's what Section 79 of the Act means. But, my Lord, with respect to our learned friends, their central argument about Section 79 is made without any engagement with my Lord's findings on the merits. They postulate a whole bunch of arguments, my Lord, but they do not ever explain to my Lord why my Lord was wrong on the Section 79 interpretation. Let me just unpack that very briefly. Firstly, my Lord, the argument that Section 79 of the Act doesn't apply to Mr. Zuma's application, as my Lord found, is unsupported by the facts, because we know that the National Commissioner firstly stated that in his decision, he took the decision to release Mr. Zuma on medical parole in terms of Section 75 of the Act, read together with Section 79. So the facts are dead against them, my Lord. The facts are not only dead against the National Commissioner, my lord, the facts are dead against Mr. Zuma. Mr. Zuma's own evidence in this case is an own goal, and my lord found that, because in this case, Mr. Zuma's counsel repeatedly forgets and fails to deal with the fact that the medical parole application form that was filled in on his behalf was stated to be in terms of Section 79 of the Act, and the profile report at the top that was submitted in terms of that application was done in terms of Section 79 of the Act, my lord. So Section 79 of the case is brought into this matter by them, my lord, on the facts. And so their evidence, and Mr. Zuma's evidence in particular, is an own goal. In fact, my lord, on this score, he, with respect to him, has driven the ball right out of the back of the net. And in its judgment, the court set those facts out in full. And despite the court having done so, Mr. Zuma has failed to explain why, in light of those facts, Section 79(1) should not have been considered as a factual matter, my lord. And so that failure by Mr. Zuma amounts to a failure to address the merits, which is, as an elementary aspect of leave to appeal applications, something an applicant in an application for leave must do. They have to address the merits. They've not told, my lord, why those facts can simply be ignored by them, my lord. And secondly, my lord, and most tellingly, both Mr. Zuma's counsel and the National Commissioner's counsel in oral argument before my lord today, they scored two further own goals, because in their oral argument, both of them tried to convince you, my lord, that medical incapacity, the term that was used by Dr. Marfa in answer to question 6, my lord, on that form, may mean physically incapacitated. My lord will recall there was much debate about, well, but medical incapacity can mean physically incapacitated. Well, my lord, but that's the Section 79 requirement. It's Section 79 that stipulates physical incapacity, which is the requirement under the Act, my lord. And just to round off this point, my lord, it is best to be clear about this. Not one of the reports say that Mr. Zuma was physically incapacitated as a result of illness or otherwise. There is not a jot of evidence before my lord that says that Mr. Zuma was physically incapacitated to meet the requirements of Section 79(1)(a). In particular, my lord will recall that the requirement under the Act is that you must be severely physically incapacitated, such that you can no longer take care of your daily activities. You can't clean yourself, you can't look after yourself. And my lord will recall in the argument I stressed to my lord that is akin to somebody who's had a severe stroke. That's the level which we are speaking about. There's simply no evidence of that at all, my lord. And then third and finally on the Section 79 point, my lord, is that our learned friends simply fail to deal with statutory interpretation under Indomeni. Our learned friends try and invoke common law principles, my lord, and the old interpretational provisions which they now invoke, suggesting that somehow my lord got the section wrong. Well, my lord, you didn't, with respect. You cited the Constitutional Court's authority in the independent education case, where the judgment by Justice Turon specifically set out the test, and which is you consider the Act as a whole, you consider the wording, you consider its context, you consider its background, and you consider its purpose to try and understand what the Act means, my lord. And so with great respect to our learned friend, Mr. Mpofu, most unfortunately, suggested by reading out from a judgment from, I think it was from Justice Goldstone, my lord, that suggested that somehow my lord hadn't properly given reasons for your judgment. With great respect, that's a disrespect to my lord and the judgment. The judgment is comprehensively reasoned. It sets out in detail the factors that my lord took into account, grappling with a very important case. And my lord understood the public interest in the matter and therefore did justice to it. And my lord commenced with a review of the language. You looked at Section 79. 79 is headed medical parole. Subsection 1 articulates that any sentenced offender may be considered for medical parole, but if requirements are met, and that is a requirement that engages the medical parole board, and it has to be involved. And the first of those conditions, my lord, under Section 79(1)(a) is that the offender must be suffering from a terminal disease or a condition, or the offender is rendered physically incapacitated. Severely physically incapacitated. My lord read the Act and its wording and gave effect to it. And you correctly held that Section 75 must be read with Section 79 of the Act, which is the only section, as my lord said, that deals with medical parole. And that there's no other kind of medical parole reserved for the National Commission. So my lord, you devastated with great respect, and correctly so, this attempt by Mr. Zuma to create some form of silo whereby there's a special type of Section 75 medical parole reserved for Mr. Zuma and a different form of Section 79 medical parole reserved for everybody else that is in prison, my lord. Well, my lord rejected that correctly because it would lead to an obvious absurdity to have one set of offenders who are required to go through one process in order to obtain medical parole, and a different set of offenders in Mr. Zuma's special camp who simply get granted medical parole if the National Commissioner decides it, but free of any substantive or procedural requirements that needed to be met under the Act, my lord. The absurdity is made more bizarre, as I've already said, my lord, because Mr. Zuma used the process in Section 79 of the Act to obtain medical parole. That was what he decided, and his doctors decided was the process that they had to follow, and they are stuck with it. They have to live with it. Lastly, on this point, my lord, on the interpretational point, because it was said that my lord didn't give proper reasons. Well, you did, because there was a suggestion by Mr. Mpofu that Section 39.2 requires some form of Bill of Rights engagement that my lord didn't properly analyze, and that my lord didn't engage in a Section 36 limitation inquiry. Well, with the greatest respect, my lord, it's unclear how that could possibly have happened. What constitutional right are our learned friends attempting to rely on? They don't tell us, my lord. But what my lord did in the judgment clearly is you explained that the right to equality militates against the interpretation which creates a special category for Mr. Zuma and such class of offenders who don't have to go through the requirements of Section 79, and all other offenders who do have to go through the requirements of Section 79. My lord explained it clearly, and you invoked the equality provision with respect to explain to the public, as Mr. Mpofu says, that a judge must explain to the public. Well, you did just that, my lord, in your judgment, clearly and with respect rationally. My lord, the fourth elementary mistake our learned friends make is around the remedy. There's the substitution order, firstly, my lord. Mr. Zuma has flagged the Constitutional Court's decision in Trencon on the test for substitution orders and has suggested that my lord got the test wrong. Well, my lord, that's simply not so. Mr. Zuma's team have only read that part of the Trencon judgment that they think helps them, my lord, where the test is explicated. But they've committed the fourth elementary mistake of not reading the judgment in full. My lord did read the judgment in full, because one sees from a lord's judgment that you considered the relevant law in substitution, including the Constitutional Court's decision in Trencon. And my lord, critically, you came to the same and correct outcome that the Constitutional Court in Trencon stressed was for the High Court's remit, namely that the High Court has a power under Section 172 of the Constitution, read with Section 8 of PADGA, to provide a remedial remedy, a just and equitable order, including the question of substitution. And the Constitutional Court was clear, my lord. It said the Supreme Court of Appeal in that case incorrectly interfered with the High Court's substitution order, incorrectly said that the High Court shouldn't have substituted. So my lord was in good company. My lord was in the good company of the High Court judge in the Trencon case, who was confirmed in the Constitutional Court, where the court said the SCA was wrong to interfere. The good judge in the High Court had balanced all the considerations, had recognized the dangers of substitution, generally speaking, and had nonetheless weighed all of those considerations correctly and come to the view that substitution was the just and equitable remedy. And said the Constitutional Court in Trencon, it was impermissible for the SCA to interfere with the High Court's substitution order in those circumstances. And the Constitutional Court said that's for the very well-known rule that where there's a discretion granted to a judge, as there is to my lord on remedy, an appeal court does not ordinarily interfere with such a discretion unless there are exceptional circumstances. And my lord knows the test. There's a palpable error. There's an unsound reasoning. None of that can be said in my lord's judgment whatsoever, my lord. And that is for this reason. And I need to deal with it because you debated it with our learned friend, Mr. Mpofu, this idea that somehow it's incorrect to send Mr. Zuma back to prison because he's already somehow serving his sentence on the basis of medical parole, and that it would be to punish him to send him back to prison. My lord, with respect, that argument is wrong for four quick reasons. The first reason is, as Mr. Jamie has already highlighted, this case has nothing to do with prisoners' rights, my lord. It's not a case about Mr. Zuma not having his rights in prison or not. Those rights have been respected to him. He got medical treatment. He was given the best treatment he could. And the question in this case is about whether he was granted medical parole correctly. It's a very separate issue. Second point, my lord, is it's not relevant that Mr. Zuma didn't make the decision. and that somehow he should now not be punished because this decision was made badly on behalf of him by the National Commissioner? Oh, my Lord, no. That misses the point entirely, with respect. He has been punished. He has been punished. The Constitutional Court, my Lord, took into account that he's an elderly man. You can go and reread its judgment in the contempt application on sentencing, my Lord. It takes into account when it determines what is the appropriate sentence for Mr. Zuma, that he's an elderly man, that he may have a whole range of factors going towards a sentence different to 15 months imprisonment. The Constitutional Court said, we've weighed all those factors, but we found that in the circumstances of this case, 15 months imprisonment is the appropriate sanction. That's what the court has determined, my Lord. So he has been punished, and all my Lord has done, and this is the third point, is that my Lord has recognized that the punishment that the court handed out has been interrupted or undone by the fact that an unlawful grant of medical parole took place. The moment my Lord finds that it was unlawful, my Lord has no discretion. You have to, under 172(1)(a), say that is unlawful. And the moment my Lord says that the medical parole granted is unlawful, what happens, my Lord? The original sentence that the Constitutional Court behind that order granted for 15 months imprisonment simply stands. It's then reinstated. Mr. Zuma must return to continue serving that sentence, my Lord. So that is a 172(1)(a) obligation that my Lord was obliged to exercise. And my Lord, importantly, the fourth reason, my Lord, in your judgment specifically said under section 172(1)(b) that you took into account the fact, that the 3 months that Mr. Zuma had been entitled to medical parole shouldn't count in the overall scheme of things. Why, my Lord? Our learned friend Mr. Mpofu says nobody knows. Well, that's not so, my Lord. My Lord, in your judgment, you specifically said that one of the factors you took into account here was that Mr. Zuma was continuing to offend the Constitutional Court's order. You specifically referenced that in your judgment, my Lord. And so you said that that may be one of the factors which counts against the type of compassion and mercy that our learned friends say ought to have been recognized in the circumstances, at least in the balancing exercise. And my Lord has done that balancing exercise, and no appeal court without a very clear indication of how you've erred, and there is none here, my Lord, would interfere with what my Lord has already ruled. My Lord, then the fifth error, and very briefly and finally, my Lord, there is, by our learned friends, and I understood Mr. Mpofu in his opening address to sort of reserve his rights in this respect, to contend that there might be a need for them to supplement their arguments because they hadn't had enough time to file their application for leave to appeal because this hearing had been scheduled quickly. With respect, my Lord, this hearing was scheduled quickly because they filed their leave to appeal application on the afternoon that my Lord gave the judgment. They were the ones that were quick out of the starting blocks, my Lord. They were the ones that wanted to file their application for leave to appeal immediately. And my Lord, quite correctly, in light of the years and the fact that all of us are going away and the importance of this case, has determined that it should be heard today. Well, my Lord, with respect, they cannot now come and complain that they got out of the gates so quickly by filing their leave to appeal application urgently that they somehow have been prejudiced, my Lord. That's, if they are prejudiced, that's again an own goal by them and the legal team coming out of the starting block so quickly, my Lord. They had the time that they wanted to, if they wanted to file a leave to appeal application. They decided to put it in on the afternoon. My Lord, in any event, there's a further flirtation by our learned friends in Mr. Zuma's leave to appeal application to say, well, they might need to lead further evidence, my Lord. Well, with respect, my Lord, they must lead whatever the evidence they want, but they haven't done so. They haven't disclosed on what basis they are going to be able to do so or why they haven't done so. And they know, my Lord. Our learned friends are well aware of the very, very high standard that an appeal court lays down for leading further evidence on appeal. You need to explain why you didn't do it at the time that it was available to you. You need to explain why it's in the interest of justice that it should be received by the court. And my Lord, they've not even come close to explaining how they might meet that test, my Lord. And then finally, my Lord, in this respect, our learned friends, and I must deal with this very briefly, they raise the fact that there will be some or other prejudice to them because my Lord called for this hearing today. And as a result, they're going to somehow be denied an opportunity to raise a new point that they want to raise about the fact that the applicants in the original review didn't exhaust some or other internal remedies under the Act because we didn't apply apparently to the review board, my Lord, before we came to the High Court. Well, with respect, my lord, obviously there's an otherworldly nature to that type of argument. Firstly, because their new point is a dead one, because if they wanted to raise it, they had to do so in the main review for proper debate and argument. You can't keep a point, my lord, in cold storage and then microwave it into life after the hearing at the leave to appeal stage. That's not how it works, and our learned friends know that. But even if you could try to microwave it, my lord, it's stillborn legally for two glaringly obvious reasons. The first, my lord, is another own goal. Remember, our learned friends keep telling my lord that the HSF and freedom under law and the applicants generally don't have standing in this case, my lord. They don't have standing to even be before my lord. So on what possible basis would any of us have had standing to go before the review board under the Act? We would have had absolutely no standing whatsoever on their own argument, my lord. But in any event, my lord, there is a further difficulty with their argument, because when you go and read the section on the powers of the review board, my lord, the powers of the review board are limited, my lord. The powers of the review board are only to hear any aspects of the decisions by the parole board. That's the Act. The Act says that. It's to hear decisions of the parole board and to sit in review of decisions of the parole board, not of the National Commissioner, which is what we're dealing with in our case. So it's an entirely irrelevant point in any event, my lord, raised belatedly as it has been in the leave to appeal application, but never before prefigured. So, my lord, those are our submissions. I might just conclude, if I might, my lord, in 30 seconds by saying that it is quite incorrect for our learned friends to suggest that you have some other separation of powers difficulty, my lord, and that you erred as a court by overriding the decision of the National Commissioner. My lord, they've invoked the case of State versus Botha in this respect. My lord, you will read that case in your own time. It is entirely distinguishable with respect to them. That case dealt with the imposition of a non-parole period at the time of sentencing. So that it was a case about sentencing. And the question was whether there was any other basis to interfere with that sentencing. And said the court, you need to ordinarily show respect to a sentencing decision. Well, that's entirely different from what we're dealing with, my lord. Here we are concerned with the court's review functions in relation to the unlawful grant of medical parole by the National Commissioner. So Section 172 power in the heartland of what my lord has been able to do as a judge in a review court alongside all other judges in this country. And very importantly, my lord, is it doesn't help for our learned friends to flirt with Bato Star and other decisions, because they failed to engage with the judgment I set much store by in our argument, my lord, in which you referenced in your judgment. It's the Democratic Alliance judgment, the Similani judgment of the Constitutional Court, which came after Bato Star, my lord, and which says, in a rationality review, which is what we were dealing with in this case, is the National Commissioner's decision rational? In a rationality review, said the Constitutional Court, separation of powers doesn't come into the picture. If it's irrational, the court must declare it to be so. And that's exactly what my lord did for the factual and legal reasons that were stipulated. And of course, if any body is to be shown deference or respect, my lord, in this case, it's the medical parole board. Those are the 5 expert doctors. Those are the people independently tasked with making a decision, a very important one, which they knew would be scrutinized in this country closely. And they said, we've looked at this. We've looked at the updated evidence. We've gone way past what Dr. Mafa said more than a month ago. We've got all of the medical experts that we asked for. We've looked at their evidence. We've looked at what the requirements are under the Act, and we've come to the view that Mr. Zuma is not liable for medical parole. Why? Because his condition has stabilized. So, my lord, that is where deference is owed, to that body, not to the National Commissioner, who is in no way medically trained whatsoever. So, my lord, in the closing 10 seconds, we submit that the application for leave to appeal should be dismissed with respect to our learned friends, or both applications should, with costs. And, Lord, that quite obviously, this matter cannot be slow dragged through the courts by a portended appeal to the full court, as Mr. Mpofu suggests. This case is deserving, if it does have to go up. We say it doesn't, and leave should be refused. But if my lord is minded to grant leave, then clearly it must be leave granted to the Supreme Court of Appeal, my lord. And with an indication, as I have seen done in other cases, that the matter is deserving of an expedited appeal to the extent that it does go to the SCA. Of course, my Lord's views on that score are not binding on the Supreme Court of Appeal, but they would be binding on our learned friends. Because if my Lord is minded to grant leave, we say you shouldn't, but if you're minded to grant leave to the SCA, all parties should be told that there is a duty upon them to ensure that this case is expedited in the public interest, not slow-walked for any longer than is necessary. Thank you, my Lord. Those are our submissions.
Thanks, Mr. Du Plessis. Mr. Lapska.
Great pleasure, my Lord. AfriForum delivered concise heads of argument this morning. I believe they will be in the possession of either your Lordship or your Lordship's registrar.
Yes.
The references to case law that I make appear therein. My Lord, I must make common cause with the argument presented by Mr. Jamie and Mr. Du Plessis, and I'm indebted to them for doing the heavy lifting. We kick off in respect of AfriForum's submissions. The third respondent cannot to latch onto the substitution order to lament his Chapter 2 rights, whether in respect of the declaratory relief or the substitution order. The argument, if I understand it correctly, is that this court imposed imprisonment. This court did not do that at all. This court restored the status quo prior to the unlawfulness of the medical parole decision. The Constitutional Court handed down a sentence of imprisonment. This court reviewed and set aside the unlawful medical parole decision. The substitution order follows the restoration of the status quo. Nothing prohibits the third respondent on that score then to apply again for medical parole if so advised or if he qualifies, or to apply for parole if and when he so qualifies. Following the argument advanced by the Commissioner and the third respondent, we'll denote that this court becomes the get out of jail free card for the third respondent, contrary to the Constitutional Court's order. My Lord, I refer in my head to the Montcheval Trust against the Nagoesen decision, where Justice Bertelsmann in the Land Claims Court held that the use of the word good in Section 17 indicates a measure of certainty that another court will differ from this court. Therefore, in terms of the stringent test applicable in CASI, the applicants for leave to appeal should satisfy the court that there is a measure of certainty that another court will differ with the judgment. And that has not been achieved, and it cannot be achieved. Lord, if I may briefly mention in respect of the interpretation of the Act vis-à-vis the regulations. In the main argument, I made reference to Section 79, sub 8 of the Correctional Services Act. It's provided for that the minister must make, within 6 months of promulgation, regulations. And those regulations, including Regulation 29, should regard the processes and procedures to follow in the consideration and administration of medical parole. Therefore, when applying endumeni, my Lord, and applying Section 79.8 vis-à-vis the Act and the regulations, it's patently evident that your Lordship did not err on that score. My Lord, in respect of the remainder of the grounds of appeal, I deem it not necessary to deal with each of the respective grounds. It will entail an entire day of argument on the merits again. The grounds of appeal are with respect to the Commissioner and the third respondent one-dimensional. It gives too much attention to issues that are not important and they suffer a number of logical fallacies, primarily in that the grounds of both applicants for leave to appeal fail to address the ipsissima verba of the Act. It fails to address the wording of the Act. It fails to address the reasons of Mr. Fraser and the patent illegality and unlawfulness that followed in terms of the reviewed medical parole decision. In respect of the grounds for leave to appeal, my lord, which are not good, a prime example is the attack by the Commissioner on the urgency ruling. It is strike law that an order in terms of Uniform Rule 612 is not appealable. And I make reference to the Lubambo against the Presbyterian Church of Africa case in the heads of argument. And that's, of course, because the order in question is a simple interlocutory ruling, juxtaposed to a judgment which is appealable because it's final in effect, definitive of the rights of the parties, in granting definite and distinct relief, and have the effect of disposing a substantial portion of the relief claimed. I make reference in my heads to the Health Professions Council of South Africa case against the emergency medical supplies. My lord, I also make reference to two other cases. S against Smith and Moederhuis judgment. The Moederhuis judgment is a 2021 judgment in the Free State Division. That having regard to the stringent test, there must be a sound and rational basis set out in the grounds for leave to appeal. There is no such basis present in CAS. My lord, to conclude, there is no basis in terms of which an appeal would have reasonable prospects. This is because there is no sound and rational basis providing a measure of certainty that another court will differ from this court. There is also no compelling reason why leave should be granted for an appeal to be heard. The Supreme Court of Appeal has stated in Minister of Justice and Constitutional Development against South African Litigation Centre that it is not to say that merely because the High Court determines an issue of public importance, it must grant leave to appeal. The merits of the appeal remain vitally important and will be decisive. There is no important question of law which has been raised. The administration of justice is not dependent upon the hearing of an appeal, nor is there a conflicting judgment. With respect, my lord, it will lead to absurd results if a losing party is to succeed with leave to appeal each and every time an opportunistic and incorrect interpretation of an act is adopted in lieu of a lucid reading and interpretation thereof, in terms of the plain wording of the act. The application for leave to appeal, my lord, stands to be dismissed of costs. The two applicants for leave to appeal to pay the costs on a joint and several basis. May it please you.
Thanks, Mr. Labuskaghni. I think it's an appropriate moment for the court to take a 1 hour lunch adjournment. It's 5 minutes past 12. We can reconvene at 1 o'clock. Court adjourns.
Okay.
Thank you.
I was going to, my lord.
Yes.
No, I'm sorry, before we adjourn, I was going to suggest if Mr. Mpahlele is also not going to be long, that we could just wrap up the replies. They're certainly not going to be long, my lord. But if your lordship...
yeah, but if you... okay, I thought you would need more time to reply, but if you're saying you won't be long, we can proceed. Let me check if other counsel, are they still on the platform?
Hello, my lord, yes.
Can we proceed, Mr. Du Plessis, and where's Mr. Jami?
My lord, I speaking personally would very much hope so, for the simple reason that, my lord, I'm in Cape Town and there is a power outage and I may run out of power anyway. The inverter is only going to last for so long. So if we could proceed, I'd be most grateful.
It would depend on whether Mr. Jam is still on the platform.
I'm still on the platform, just I'm not in suitable attire. I didn't think I'd need to address you again, so I don't want to come on camera, but I would very much appreciate too if the matter could be disposed of without a luncheon adjournment.
Yes, we may proceed then.
Thank you, my lord. My lord, let me then, to cut to the chase, start with Mr. Du Plessis, who, well, firstly, he starts by patronizing us, by telling us that we don't understand the test for application for leave to appeal. I mean, anyone who doesn't understand the test for leave to appeal needs their head to be examined. But either Mr. Du Plessis is blind or deaf or both, because at paragraph 7(2), which he read out, where he says we use the old test of might, page 7, my lord, of our application for leave to appeal, it says there are accordingly good and reasonable prospects that another court would come to a different conclusion. That's the new heightened test. So he just wanted to insult us gratuitously, because that is the test, and that's the test that we have used. Then he goes on to, and we don't appreciate to be patronized as such. But he then also says that that I said that there are no reasons in respect of the interpretation point. I made that point in respect of other aspects of the case as well. But particularly in relation to the interpretation point, I said, my lord, that the point about the maxim generalibus and non derogant specialibus was not addressed. And I don't know if Mr. Du Plessis can point out in the judgment where it was addressed, because that is a canon of our interpretational law. And so again, as I say, he's also deaf on top of everything else. Then, my lord, Mr. Du Plessis misses the point about what we say in respect of Section 79. Section 7, we are saying the National Commissioner said he's making the decision in terms of Section 75(7). Yes, he did also say read with Section 79, but he wants the court to wish away the fact that the decision was made in terms of Section 75(7), as if the decision was made in terms of Section 79. That's their entire case is based on that, which is not true. It's just not true factually, because the commissioner did say Section 75. In fact, I pointed out in the main case, my lord, that in the press release, the commissioner actually only referred to Section 75(7). And the question is whether that section is just there for decoration or whether it has meaning in our law, which we say it does have. Then they say, my lord, there's not a jot of evidence that he was physically incapacitated. That one takes the cake, my lord. I'll take your lordship just for a shortcut to the DA heads. I think it's paragraph 28 thereof. Yes, 27, my lord. 27 and 28. Just listen to this, my lord. A doctor says, the question is, is the offender suffering from a terminal disease or condition which is chronic? Yes. Now, chronic means it is constant. It's even worse than just a normal terminal illness. It's chronic. The answer is yes. And they say that nobody said it. And then it says, is it progressive? Yes. But here's the one that takes the cake. It says, has his condition deteriorated permanently or reached an irreversible state? He says it has deteriorated significantly. worse than what the question says. So if you say, is something, is he ill? And say, is ill significantly? How can that be interpreted to mean no? And Mr. Jamie says, had he said yes to that third question, we would be dealing with a different case. Well, that's a yes. That's a yes, 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 actually. It's more than just a one yes. It has deteriorated significantly. And they want this court to interpret that as a no. Really, my lord. I mean, that's just, you know, the kind of argument that should not even be entertained by a court like this. My learned friend, Mr. Du Plessis, then goes on about section 172.1a. But the issue we're talking about here is a section 172.1b point. It's a remedy point, not the compulsory must under section 172.1a. It's whether the remedy is just and equitable. And Your Lordship, and I'm not going to repeat the discussions that we had earlier. That is the issue on the substitution order, whether the trend contest has been met. How can the trend contest be met, my lord, when we now know, fortuitously maybe, that there is a different decision maker, a new acting national commissioner? So let's assume Mr. Fraser was biased for argument's sake. Then there is a new decision maker. That is the person who will, to whom the matter will be remitted. Where is that dealt with in the judgment? Nowhere. And how can it ever meet the trend contest if the matter is not a fait accompli, which is what Trancon says, the Constitutional Court. Anyway, so my lord, with and then Mr. Du Plessis, he of the Helen Suzman Foundation, also says that Mr. Zuma, the issues that were made about standing were made by Mr. Zuma through his counsel. That means he didn't read paragraphs 30 to 35 of Mr. Zuma's founding affidavit, or he just wants to insult me again just for no reason. Because it was Mr. Zuma who, in his affidavit, explained why there was a political motive behind this particular application, in that there are many people who are given parole, but we've never had all what he calls these right-wing organizations clubbing up in those. It was not me. And then a further insult to Mr. Masuku, also gratuitous, is that because in the freedom under law had locus standing, in some case that we don't know what it was about, therefore these other parties here have locus standing. I mean, what kind of argument is that? That because a court somewhere in the world ever found that there was locus standi for some other organization different from the ones in front of you. Therefore, Mr. Mastubu should know better and not raise the locus standi. And what is worse, he must even know retrospectively. He should have known this in November, that in December that was going to happen. I mean, well, anyway. Mr. Du Plessis is entitled to insult us as much as he wants, but he must stick to the facts at the very least. On standing, my lord, the point we make is very simple. We did not negate the case of the DA, as Mr. Du Plessis accuses us. What we are saying is that the court did not give any reason why it is finding that these parties are genuine parties. This is what the court said in its finding, the only finding actually. In exercising my discretion to dismiss the point on standing, well, that's also wrong. Because the point on standing is not a point of discretion. It's either you have standing or you don't have standing. But let's put that aside. And then it says, I have taken into account that the case raises serious constitutional justiciable issues, namely whether the commissioner exercises public power and so on. Respondents on medical parole contrary to the Constitutional Court order, and that the applicants have a genuine interest, that's the important part, in its outcome. Now, we had contested this based on the case that Mr. Du Plessis says we negated. We said at paragraph 45, I think, of that case, NAFSA JA had said that that test which they want to apply cannot apply if the applicant is malafide or has ulterior motives. And we have pleaded in this case that they do have ulterior political motives. Where is the reasoning that says we were wrong about that? Except for the conclusion that the judge says that they are genuine. And that's what I mean by the impartial point. It's a conclusion that they are genuine is not a judgment per se. Because what we want is to say, no, the applicants say that there's a political motives and so on, and they are wrong because of this and that reason. The others say they have a genuine reason and they are right because of this and that. And that is what we mean by the judgment lacking just the bare essence of what a judgment should contain. Then, my Lord, Mr. Jamie, for his part, really says that the unredacted report somehow assists them. How can it do so, my Lord? Your Lordship only had in front of him the redacted report for whatever reason. So how can your Lordship say that the parts that are redacted, for example, do not say that he's terminally ill? And the answer, my Lord, with the greatest respect, cannot lie in saying some deductive reasoning that because the parole board said he does not qualify under the Act, which can mean anything. It can mean section 791A, B, or C, or whatever. Therefore, it means that they were saying he's not terminally ill. The point of the matter is that your Lordship does not know what in fact, the likelihood is that the redacted parts of the report are those that really go to the nature of the illness. That's why they are redacted for privacy purposes rather than the opposite. And your Lordship simply does not know. So the onus bearing parties must suffer from that, because if your Lordship does not know, then they must lose, because they bear the onus to bring the proper record and convince the court of the contents thereof. And there's no duty on former President Zuma to diagnose himself. And now they say, no, he does not say that he suffered from a terminal illness. The doctor said so. He's not, even if he had self-diagnosed himself, who's going to take that seriously? Because the professional medical experts who are trained to make that determination have said that he does suffer from a terminal illness. And that's the crux of the issue. And then your Lordship finally misdirected yourself with respect, my Lord, in not realizing, or rather not appreciating that this is not a case that has been brought under section 79 2B Roman 2. So your Lordship, from paragraph 51 of the judgment up to 57, your Lordship says when an application is made by a sentenced offender or a person acting on their behalf, and then your Lordship goes on for those 7 paragraphs. But this is not, that is not this application. This application falls under section 79 2B Roman 1. An application